Good afternoon. Peter Stryantz of the Nashville Bar here on behalf of petitioner appellant Radonda Vaught. I represented Ms. Vaught in both the nursing board action and in the criminal case in the criminal court for Davidson County. Would like to begin by...
You want to reserve any time?
Yeah, oh please. Would like to reserve 5 minutes for rebuttal. Thank you for reminding me, Judge.
You're welcome.
I'd like to start this by saying that on October 23rd, 2018, Radonda Vaught walked to her mailbox in rural Bethpage, Tennessee, and she could breathe again. A medication error that occurred at the Vanderbilt University Medical Center on December 26, 2017 had been hanging over her head for about 10 months at that point when she received a letter from the Department of Health that, in my view, cleared her name and restored her license. And it is that October 23, 2018 letter that is at the heart of this controversy that you all will be deciding in this case. And without being too pedantic about it, I wanted to take a look at the letter and walk through the letter. It's very short. It was Exhibit 8 at the administrative hearing that we had at the nursing board. And I'm struck first by it's addressed to Miss Vaught. Her first name is misspelled, to her address in Bethpage, Tennessee. And I was struck by the Ray section, which begins disposition of complaint. And I'm not a big Black's Law Dictionary person, but I pulled out Black's Law 7th edition, and they define disposition as a final settlement or determination. Then you get to the text of the letter, and it's written by Antoinette Welch, a former Assistant District Attorney General who at that time was the director of the Office of Investigations for the Tennessee Department of Health. And she begins her letter with, "Thank you for the work you have done with us through this necessary process." And I sort of paused on the word process. A complaint which was filed against you was forwarded to the board consultant for disposition. There's that word again, for disposition after investigation. After review by the board's consultant and a staff attorney, which is significant. You have a consultant for the board, you have a staff attorney for the board, and you also have the director of investigations for the board, all making what we characterize as a final decision and a final determination in this case. After review by the board's consultant and a staff attorney for the Department of Health, a decision was made, a decision, back to Black 7th edition, a pronouncement of judgment after consideration of facts and law. The purpose of this letter is to inform you of the outcome, and the outcome of this letter was determinative of the entire action. The McFarland case that I cited in my brief, I think teaches that governmental action is quasi-judicial even when it executes laws already in existence.
Counsel, do you have any authority where a Tennessee court has given res judicata or collateral estoppel effect to a letter of this type?
I don't have a case that says that, but Your Honor, when you take a look at 63.7.116b, and you look at the plain text of that statute, no hearing is needed if a complaint that is initiated by the nursing board is found to be unfounded. The plain text of that statute, Section B, unless the charges are dismissed without a hearing by the board as unfounded or not warranting further investigation, the board shall then take other actions. So in my reading of the text of that statute, that's a final quasi-judicial determination of what was the complaint against Ms. Vaught at that time.
Are you aware of any cases in any other jurisdiction that have treated a letter of this type have given it res judicata or collateral estoppel effect. And there's not a Tennessee case that you're referencing us to.
Right.
Is there a case from any other jurisdiction that you're aware of that has given res judicata or collateral estoppel effect to a letter of this type?
No, but I think it's much more than just a letter. I think it is a final
A
determination.
letter of this type. I mean, this is not the only letter of this variety that has ever been issued by a governmental agency. I'm struck that there isn't a reference in your brief, and probably it may not exist. And it's part of the reason I'm asking the question is in case it does exist. I think it would be a matter of great importance. Has a court ever taken a letter of this type and to this extent and disposition and outcome and the language you're referencing? And that's not the first time a letter like that has ever been issued. Has any court ever given that type of letter res judicata or collateral estoppel effect? And it seems like you're asking us to step into a place that I'm not sure I've seen a court go before with regard to, and it doesn't mean it's wrong, but I'm just trying to understand the ground we're being asked to step out on.
I don't think that to invoke res judicata, there has to be some formal hearing that was conducted. In fact, taking a look at the statute I just cited to the court, that indicates that there should be no hearing that follows.
Are you aware of any court, though, that's ever done it under these types of circumstances, where it's a letter of this variety saying that we've reached that disposition, that outcome, and is there anything you can reference us to that shows somebody's taken something comparable to this and said, yes, res judicata applies there?
Well, I think this case in some ways is sui generis. I've never seen a situation like this where the nursing board brings an action, a complaint against a nurse, fully vets it, does its own investigation with the assistance of professional investigators, and is moved on its own to write a letter like this. And then the timing of this is very interesting. After they send their letter, a few months later, the Davidson County District Attorney decides to charge this woman criminally. They have egg on their face at that point in time, so they scramble around to undo this letter. And the basis of my argument is the text of that statute. The statute doesn't require that there was some fancy hearing that involved the taking of testimony and witnesses. It says that this board, the Department of Health, has the inherent statutory authority to ferret out unfounded complaints. So when they ferreted out this unfounded complaint, it was over for all purposes, is the argument that I make to this court.
Isn't opposing counsel going to tell us essentially, though, we found out additional information? I understand your contention that this is being driven by other things other than new information, but they're going to say we found out new information, it developed, and that's why we changed our course in terms of...
If they get up here and say they found additional information, they're going to be arguing outside the record. Yeah. There is no suggestion there was any additional information. When this event happened at the Vanderbilt University Medical Center on December 26, 2017, Nurse Vaught talked to anybody that would listen to her about this medication error. Not only was she interviewed, not only did she give a narrative statement, she also gave what was supposed to be a privileged and confidential veritas statement that she made to Vanderbilt University Medical Center. So there were no additional facts that were discovered. She was interviewed by investigators prior to them making this decision. So I don't know what other facts there could have been. And in fact, all that information was used against her at the administrative hearing that we had in the summer of '21. It's our insistence that the letter that I've just reviewed with the court, by its plain terms, does represent a final quasi-judicial agency determination, and that the McFarland case that I mentioned before, an action of an administrative body is final when it's a decisive governmental act. I don't know what could be more decisive than this letter where they're telling Nurse Vaught, we've taken a complete look at all the facts and circumstances that were well known to them at the time, and basically cleared her name at that point in time. The issues that were raised in the initial complaint that began with this letter that refers to the process that they went through, as well as the subsequent adversarial hearing that we had before the nursing board, those issues were identical. I don't know what the state can get up here and tell this panel was different and what additional information that they had after they sent this letter, because for all intents and purposes, the investigation was over.
As is your time.
Oh, thank you.
Thank you very much.
Good afternoon. My name is Ryan Gallagher. I represent the Board of Nursing. May it please the court. I'll start with the res judicata issue. So we're picking up where the court left off. We're not going to tell the court that we have additional information, that these two complaints were based on additional information. The complaints are not in the record. All that's in the record is that there's two different complaint numbers. But the basis of our argument is that a letter declining to bring charges is not a final judgment. Res judicata requires a final judgment. And this is not a final judgment because the agency was not acting in its judicial capacity. It was acting in its prosecutorial capacity. A prosecutor decides whether to bring criminal charges. The judge or the jury then adjudicates those charges. So when the department sends a letter saying, we're not going to press charges, that's a prosecutorial decision. Res judicata doesn't apply to a prosecutorial decision. And second, opposing counsel mentioned the case McFarland versus Pemberton. That case shows the hallmark characteristics of a quasi-judicial decision. Footnote 33 of that case lists the kinds of things that courts are looking for when they're trying to determine whether an agency is acting in its judicial capacity. And so the Supreme Court says, each side was permitted to submit evidence and briefs in advance. At the beginning of the hearing, there was no hearing here, the chairman outlined the law governing the commission's factual determination. The parties were allowed to make arguments. Other interested citizens were allocated time to give statements on behalf of the parties. And importantly, a court reporter made a record of the hearing. With this letter, none of those characteristics are here. There was no hearing, there was no discovery, there's no record, there was no litigation whatsoever between the parties. And therefore, res judicata does not apply in this situation.
Was there, when the department decided, or the agency decided to, I want to say reopen, but was it you said it had a different number? There are two different case numbers or something?
Yes, Your Honor, that is correct.
Okay, when the department decided to open a new case, was there a rule or anything that allowed them to revisit such letters that were issued before?
So there is testimony in the record from the investigator who investigated the second complaint, and she testifies that it's very common for the department to reopen investigations when they receive additional information. Now, because the complaints aren't in the record, I can't stand up here and say that that's what happened in this case. We don't know, but it is fairly common for the department to reopen an investigation once additional information is.
And they reopen it under a new case number?
That is correct, yes.
Number.
At least that's what happened in this situation,
okay.
Yes. And I'll briefly turn to the second issue in the case.
Excuse me for interrupting, counsel. Has your research uncovered any cases either in Tennessee or other jurisdictions with regard to a circumstance, a situation as we have here?
No, Your Honor. I could not find a single case saying that a letter declining to bring charges is a final judgment on the merits.
Thank you.
I'll briefly turn to the second issue in the case involving the letter from Dr. Terry Bozen. The appellant has argued that the board's decision rests on unlawful procedure because the board did not consider this letter. Now, the glaring problem with this argument is that the letter from Dr. Bozen was written 9 months after the contested case hearing. So the board could not possibly have considered a letter that didn't exist at the time. So the argument fails for that reason alone.
Could, if the nurses' council had determined to do so, could they could have elicited, or could they have elicited testimony at the time of the hearing that basically is the subject of the letter?
Yes, Your Honor.
I mean, that wasn't, the letter wasn't new stuff. It was stuff that was known at the time of the hearing. Is that right?
In essence, yes, that is correct. The letter essentially says that Vanderbilt's medication dispensing system is bad. And Dr. Bozen testified at the trial. She testified about the override function. Appellant herself testified about the problems with Vanderbilt's medication dispensing system. The Chancery Court found that counsel could have elicited this information on cross-examination. I think the one piece of the letter that maybe is arguably not in there is when she says that Vecuronium being on the override list is what caused this tragedy. That I couldn't find exactly in the record. But the general problems with Vanderbilt's medication system, that is in the record for sure. So I think it's really that one sentence that Appellant is relying on mainly here. But that would not affect the merits of this case, because what the board cared about is the fact that Appellant did not read the medication label. That is the crucial fact. And in the board's decision, in paragraph 9, they find, based on Appellant's testimony, that she didn't read the label. That's an undisputed fact. And the deliberations show how crucial that fact was to the board's determination. So 3 quotes from the board's deliberations from the members. Ms. Wyatt, even if it had been chosen correctly, you still have to verify because machines can mess up just like humans can. Ms. Wright, so human error can occur and they can put the wrong medication in there. That's why we're charged with reading the medicine, reading the vial, verifying always. And then lastly, Ms. Turnipseed. Yes, there's lots of other things that could have been done, maybe done by the facility, but you have to verify the drug. You just can stop there. That last quote in particular makes the point that I'm trying to make here, which is the board was aware of everything that was going on at Vanderbilt in terms of the override function and all of that. Yes, there's a lot of things that could have been done by the facility. They're acknowledging what happened at Vanderbilt. So additional information from that letter is not going to change the board's mind because you have that fact that she didn't read the label, and that was what the board was focused on. So unless there are more questions from the court, I will conclude by asking for this court to affirm both the decision of the Chancery Court and that of the board. Thank you.
No more questions. Thank you very much.
If the panel was to compare the testimony of Terry Bozen at the administrative hearing, and I know you don't have the criminal transcript of the criminal trial, but just comparing her testimony to the administrative proceeding, markedly different than what she wrote to Judge Jennifer Smith in the criminal case about her concerns about the dispensing system, the automatic dispensing system at Vanderbilt, and the issue of confirmation bias, which she never testified about. She was cross-examined by me about the problems that Vanderbilt University Medical Center was experiencing, and she gave terse responses, and that's in the transcript. But as far as the concerns that she had when Ms. Vaught was facing sentencing in a criminal case that motivated her to send this letter, and that only got that letter on the day of sentencing. I did ask the chancellor to remand the case back to the nursing board to revisit the testimony of Terry Boson, but the chancellor did not want to do that.
Did the chancellor say why?
I can't remember, Judge, to be honest with you, but she entered an order denying my motion to remand it. We had a hearing on it as well.
Was there anything in that letter that could not have been elicited at the time of the hearing?
I think so. If Ms. Boson felt the way she did when she wrote that letter, I don't know why she would not respond that way when we were having the administrative hearing and I was cross-examining her about the problems at Vanderbilt University Medical Center. She took the attitude, well, it was no big thing. And then we go down the road months later and it becomes a very big thing when I don't know what motivated her to write the letter, but she expressed in that letter more than just a character reference for Ms. Vaught, but some real structural problems that she had seen at Vanderbilt and how, although she didn't read the label, this confirmation bias could have been a major contributor to the medical error and accident that occurred.
Couldn't confirmation bias have been raised before the nursing board and in the earlier proceeding, even if it wasn't through this particular witness? And couldn't that issue have been addressed further before the nursing board in the initial hearing?
I suppose it could. I was struck by the disparity between her testimony at the adversarial administrative hearing and then this information that she includes months later in a letter. That's why I thought remand would be appropriate. I think the crux...
Is that letter in the record?
It is in the record, yes, sir.
Thank you.
You know, the crux of our argument is that this is a final judgment, and the reason that I make that argument, and I understand that there are no cases on point about res judicata and a letter, but I didn't write 63.7.116b, and when you read that, that indicates that the board has the authority to dismiss without a hearing if they find the complaint to be unfounded. So it would have ended right there. So I believe based on that that is a final judgment of the nursing board.
Counsel, under your argument, if there was newly discovered evidence, would the board be able to proceed? So if they issue this type of letter and then they obtain new information, could the nursing board proceed in that scenario?
If at an evidentiary hearing they could demonstrate that they had new evidence that they didn't have when they made the decision to write the letter, then yes, I would agree with the court. But if they were unable to get on their feet and said they had any new evidence, I think they'd be bound by 63.7.116b. Thank you.
Thank you. Thank you both. Would you call the next case, please?
Tatum M. Campbell versus TC Restaurant Group, LLC et al.